I'm sorry. I'll try this. I don't know if I know all you guys' names all, but okay. Yeah, I should know. Okay, so Commissioner Roney.
Here.
Commissioner Boggs. Commissioner Boggs.
Here.
Sorry, didn't say that loud enough. Commissioner Hill.
Here.
Vice Chair Walker.
Here.
Chair McCready.
Thank you. Here.
Commissioner Basasha.
Here.
Commissioner Akins.
Here.
And Museum Representative Lewis.
Here.
And I would just like to add that I was requested to have Kerry Miller here to give a update on the theater, and he is in the audience.
Thank you.
Just to let you know that. Thank you.
Thanks a lot. Do you want to say first, we're glad to see Commissioner Basaccia here. You were missed. Welcome.
Thank you.
Welcome back. Welcome home. We will start with the consent items. I'm going to switch things around a little bit here. We're going to do the historic preservation new commissioners election later on in the agenda. So we'll start with the minutes and move on to the Neff Lounge item, which is item number 6. So if there are any commissioner comments on the minutes of December 11th, both the special meeting and the regular meeting, we'll start with the special meeting. Any changes or comments that we need to put into the record? I've reviewed it. I have none. That was the Neff Lounge item for the special meeting of 11th. None?
I move that we accept the minutes of the special meeting as written.
I'll second.
Is so moved? Or, I'm sorry, do we vote on that?
Yes, okay. Commissioner Rooney.
Yes.
Commissioner Boggs.
Yes.
Commissioner Hill. Vice Chair Walker.
Yes.
Chair McCready.
Yes.
Commissioner Basasha.
Yes.
Commissioner Akins.
Yes.
It is so moved?
Yes, so moved. Thank you.
Thank you. So on the minutes of the regular meeting, also December 11th, any comments from the commissioners or changes? Spelling errors? I saw none. We usually have one spelling error.
Yeah, I didn't see any either. So.
I couldn't find any.
Do we have a motion to approve?
I move that we approve the minutes from the regular meeting for December 11th, 2014.
Do we have a second?
I'll second.
Thank you.
Roll call. Okay. Commissioner Roney.
Yes.
Commissioner Boggs.
Yes.
Commissioner Hill. Yes. Vice Chair Walker.
Yes.
Chair McCready.
Yes.
Commissioner Basasha.
Yes.
And Commissioner Akins.
Yes.
Okay, so moved.
So with our rejuggling of the agenda, we're going to move directly to item number 6. And this is a review of, and discussion of the application for the work permit granted and appealed. And some of the commissioners were not available to attend either one of the hearings, the special hearing or the appeals hearing. So that is the purpose of this sort of postmortem here tonight. So with that, I'm going to open it up to public comment. I have 2 comment cards. I'm assuming they're both on the Neff Lounge. So,
Chair McCready, can I just make one request?
please.
Can the gentleman please identify himself?
Thank you, Mr. Chair, members of the commission. I'm Scott Howard, Assistant City Attorney. I'm your legal advisor on this item tonight.
You're assistant, you're not our attorney?
I will be your interim city attorney beginning February 1st.
Thank you.
I've been the assistant city attorney since 2011.
Thank you.
Thank you.
David Mason.
David Mason, El Paseo Road. I really wasn't going to just talk on the Neff Lounge, so if that makes a difference. But I would like to give a little talk for a few minutes on remembering Ojai's greatest benefactor, which would include the Neff Lounge. And I thought it was time that we kind of refresh our memory on Mr. Libby. The year was 1908 when Mr. and Mrs. Edward Drummond Libby came to town. At first they thought the valley was beautiful, but the small town of Nordhoff did not hold the same respect as they gave to the surroundings. The town was a typical small western town, board sidewalks, and each door had a false front that was supposed to give the town dignity. The town, well, using Mr. Libby's word, was ramsackled. Mr. Libby decided that this would be a perfect opportunity to practice his idea of creating a dream city. First, he hired a young and up-and-coming architectural firm from San Diego by the name of Mead and Requa. They designed the downtown in the Spanish style that would add uniformity to all the stores. Then, to cover the old dilapidated hotel across from the stores, he designed a graceful pergola that would give it a grand entrance from the street. And for the centerpiece, they created a beautiful and breathtaking post office tower that rose up 75 feet into the lower heavens. The completions of these buildings brought joy to the local citizens, and they proclaimed it was time for a party. They would call it Libby Day. But the modest man said no. It must be called Ojai Day, to celebrate all that Ojai would stand for in the future. So the party in 1917 was indeed the first Ojai Day celebration. At the party, Mr. Libby was asked to say a few words, and the short speech was very typical of this man from Toledo, Ohio. There has been too little attention paid to things aesthetic in our communities and in our homes. The time has come when we should encourage in ourselves thoughts of things beautiful and higher ideals which encourage and promotes, must awaken in the people the fostering of the love of that which is beautiful and inspiring. Next came the fire of 1917. The Catholic Church and the small houses on the block next door to the arcade burned to the ground. Mr. Libby returned to Ojai to inspect the damage. What he did next was to buy the old dilapidated hotel across from the stores and tore it down and gave the land to the city for a park. Then he bought the block where the houses had stood, and he built a beautiful hotel, the El Roblar, now the Oaks. And for the Catholic Church, he had Requa design a building that would complement the architecture of the downtown. The structure resembled one of the beautiful original missions. Today, it's the Ojai Valley Museum. The poor man probably thought he was finished, but, well, the railroad decided to buy the 360 acres across the street from his house on the Foothill Road and cut down the oak trees. They had wood-burning engines, and they needed the wood. Mr. Libby put a stop to it, and he created the beautiful Arboleda. He hired the young Santa Barbara architect, George Washington Smith, to design model homes for his development. And he donated part of the land for use for the Ojai Valley School. And through it all, he insisted that none of the trees be touched. He then decided the town needed some recreation. He commenced by purchasing the 220-acre Dunn Ranch and had another young and soon-to-be successful architect, Wallace Neff, design a clubhouse that's set in the middle. of what would soon be California's most important golf course. From the knoll where an imposing clubhouse was being built, you could cast your eyes to about any point of the compass and see nature's rich gifts of hill, canyon, valley, and forest that would spread out before you in a wonderful way. The word spread of this new place, and people came from all over the state to view this wonder. It opened on February 15th, 1924. Among the early visitors was a Navy lieutenant from San Diego who flew a military plane up to the country club to check out the new place. He had heard so much about it. After circling the clubhouse and the golf course a few times, he decided to land on the greens and take a closer look. He made a bad landing and he ran the nose of the plane into one of the sand traps. It broke his landing gear and the propeller. After a few days, the damage was repaired, but in leaving the golf course, he struck the high-tension power lines along the road and crashed again, landing right side up by pure chance. And once more, he damaged the landing gear and one of the struts. Repairs were again brought up from San Diego, and the lieutenant was finally able to return to his home base. The first week in November of 1925, as Mr. Libby was preparing to leave Ohio for Ojai, he caught pneumonia and died. At the memorial service, the Reverend had these words to say. We are all quieted by the loss of a great man. We needed him. We wanted him. We loved him. We are humble. We are reverent. And we are sad. Help us to be true to the vision made clear by the one who has gone. Help us to love our city by every good work and deed. Mr. Libby was endowed with great vision and high ideals, an inspiring character. To know him was to love him. His energy was boundless, enthusiasm that of a perpetual youth. His good works are many. However, his greatest deeds were wrought in the lives and the hearts of untold numbers who were thrilled by his example and who quickened to greater efforts and to greater achievements through his inspiring leadership and increasing help. His contributions to Ojai didn't stop there. After his death, his estate still found to be to his liking by donating the lot on Main Street of Ojai for the building of a new library, which opened in 1928. And 75 years later, they made a substantial donation to the restoration of the pergola. If it were not for Mr. Libby's contributions and visions, the little town of which we are so proud would never have come into existence. Thank you.
Thank you. That was lovely. Thank you very much. Pat Tumame, please correct my pronunciation if you will.
You did good.
Thank you.
Patrick Tumamite, local resident. I'm here to talk about the archaeological resources other than just historical stuff. And it is part of the historical as well because, as David was saying, in 1917, the name was changed to Ojai, which phonetically means the moon. The proper name is Ojai, and it was a village site just above Ojai towards Santa Paula. Now, to do something like that in order to commemorate the native community is something that you have to be very proud of and treasure. And I ask of you as a commission, historical commission, which, you know, there should be a balance between prehistoric and historic because we were here first. The idea is that I need your help. I need your advice. I need you as a community of people who live in this valley and respect what David has said tonight about this valley and the indigenous people who live here as well. So I ask of you for your assistance, your help in trying to better protect the archaeological resources that people are ignoring to see and that are important to us as a community of people who live here in the valley. We treasure this valley for everyone to live in, and I'm not asking much. Believe me, I am not asking much compared to what has gone through historically and through the council of this valley. So I ask you tonight, please hear me out, and maybe we can work together someday and achieve these protections to our standards as Native American people treasure. Thank you very much.
Thank you. Are there any other speakers or any other people that wish to speak in the public comment period? With that, we'll end the public comment period and open commission comment period. Are there any commissioners who wish to begin?
Which item are we on?
Neff Lounge comment period, commissioner comment period.
I'll start.
Commissioner
What can I
Boggs?
say? What can I say? What would Zelma Wilson say? She was so good at dealing with controversy. Would anyone listen? I say thank you to the overwhelming support of our commission from the community, the city's citizens of Ojai who have sent emails, who have written thumbs up to the newspaper, and letters and articles to the newspaper, and have had conversations with us. The support is greatly appreciated, and that's why we bought cookies tonight to thank you. And I'm sorry there's not more of you, but you can eat more of the cookies then. It has been a learning experience, what happened in December. I was a school teacher for many years. One word that came to mind about this was excuses, dictionary version. 1A, to make apology for. B, to try to remove blame from. 2, to disregard as of trivial import. 3, an expression of regret for failure to do something. I do not accept excuses. Strong leaders do not make excuses. You've heard the one, the dog ate my homework. Well, there are no dogs at City Hall. In November, our commission meeting was canceled because staff did not have time to prepare our reports. Reports of, 5 or 6 pages. But in December, we received staff reports of more than 100 pages. We are volunteer commissioners who have a commitment to preserve our heritage. But times change. Is it time to get a demolition permit? And is it time to demolish the Historic Preservation Commission? We get no respect. We have no money. We have no power. Well, I'll tell you what we do have, and that is integrity.
Thank you, Commissioner Boggs. Any commissioners wishing to speak now?
I have some.
Commissioner Akins,
Questions, please?
is your mic on?
It is now. Sorry, it's just clearing my throat before I turned it on. I just had some questions, probably of Mr. Scott Howard and Ms. Wold. As Councilwoman Boggs inferred to, a meeting was held here, a joint meeting between the Historic Preservation Commission and the Planning Commission, went 2 hours and 25 minutes according to the minutes. However, when we were then attended a meeting 18 days later on the 29th, apparently no minutes from those meetings were presented to council. Is that true? Anybody want to answer that?
That's true.
Were any draft minutes presented to council?
No, they were not.
So no reporting of any kind from that meeting, that joint meeting that was called, special meeting called, was presented to the city council.
The staff report included the action that was taken by the HPC and the Planning Commission.
It did in summary snippets.
That's right.
Okay. I found that really difficult since we were called in for a special meeting for 2.5 hours prior to then another meeting, and everything that we spent time in preparing for that meeting was in no way taken in council by the city council that night. It was interesting for me to note that of the 5 city council members, Councilman Blatz was present at our meeting, just like appreciate Councilwoman Clapp being here tonight. And sorry, I was thinking of her daughter. Thank you for being here. And then Councilman Wyrick watched it on TV. As far as I know, the other 3 council members, nobody came forth and said that they had watched what we had spent 2.5 hours discussing. Is there a reason draft meeting minutes weren't made available to the council?
Gee, I'm in an awkward position now because Commissioner Boggs just said she accepts no excuses. Staff was, the administrative staff was directed to prepare a draft, and you know, obviously, standard procedure for minutes is to prepare a draft and take them to the next meeting, which of course that couldn't have occurred. But I left for the holidays, Christmas in between that, and I directed staff in my absence to have them completed and marked draft and in the packet, and that did not happen.
Okay, thank you for that.
So excuse me for making excuses.
We understand holidays. I guess in looking at some of the things that that were presented by you, Ms. Wold, we held the meeting on the 11th, and then 18 days later, many of us were sitting in the audience for the city council meeting. There was an inference, actually, I think, kind of a statement of fact, but a misstatement of fact that the items that the Ojai Valley Inn was pressing for had been amended, had been modified since the December 11th meeting, and that was something that you shared with the city council at that time. And I remember turning to Councilman Walker and going, no, these are exactly the things. So I think the impression that I got as a member of the commission and also sitting in the audience was that the Ojai Valley Inn had heard what took place in the joint meeting and had made modifications when in fact they had made no modifications.
Yeah, I can't really speak to that. What impression you got? The issue that was trying to be presented in the staff report was that the historic report that was done on the 4th or the 5th, it was on the 4th and then amended on the 5th, that things that noted in that report, there were things noted in which they changed their original proposal. So as it were presented originally to staff, it was amended. I don't believe there was anything else, was there, Diana? I don't think so, but I think that might have been, I mean, I don't know if it came across as being misleading. I really don't know, but that in the truth is what happened. Their original proposal, we required them to have a historic report, and in doing so and getting a historian out there, all these things came to light that they were going to touch. They were in the fireplace, the water fountain, and all these things, and then they amended their proposal. I think the only other thing that, that they did in between the two times, between the two hearings, was that they did present a couple of different other artist renderings to give a different view. You didn't have those for your meeting. I don't know if there was, so there was additional information submitted.
Yeah, that was available at the city council meeting.
Right.
That had, and that takes place with the 18 days afterwards. In looking at looking at what was presented to us in the 11th meeting, what was presented on the 29th in the city council meeting, it seems like there's some confusion that I don't really think needs to be confused. In the presentation, both to us on the 11th and then on the 29th, the architect presented the plans for the Neff Lounge and inferred both in the 11th and on the 29th that the plans, first he factually stated based on the plans that they had acquired that originally they appeared to indicate that there were doors on either side of the east wall, on either side of the fireplace, that were planned to be there according to the drawings. In the 11th meeting on the 11th and then again in the meeting on the 29th, the inference was put before us and then before the, in the presentation of the city council that possibly there were windows there and that they were changed to doors at some time. And I have seen nothing that indicates that there were ever doors there other than in the minds of the original architect. And that inference that there were doors there before was laid without any contradiction to there being there. I mean, everything that we've seen as far as pictures, including the Arbolada book, which was put together to advertise the Ojai Valley Inn and the Arbolada, indicate that they were always windows. Postcards, I collect postcards. I have hundreds of the Ojai Valley. They indicated they were always windows from the postcards. Pictures that we acquired from the Ojai Valley Museum, my being on the board of the museum, indicated that they were always windows. And again, that inference was laid there that, oh, you know, the doors were, and I can see it in the report, the plans indicated that it was originally meant to be doors. Possibly there were doors, and now we're just returning it from windows back to what they originally were in doors. And so I have a question when people say things and then they're not factually corrected, misstate things and not factually corrected.
Well, I can say is that happens often when any applicant comes up here and comes to the podium. You know, they're not sworn in under oath. I mean, they plead their case and they advocate for themselves. In my staff report, I thought I was very clear in saying this is what the applicant presents. That those plans that came from the Huntington, is that where they came from? Those came in they came in very late in the game. And were presented in, there was no, staff was very clear that those came in very late in the game, and we were seeing them, and, you know, I never saw a physical copy of them. I saw them up there, and so obviously we just presented it. That's what the applicant is indicating, you know. Mm-hmm. So I think it was very clear that there were different viewpoints on that. I think that there were people from the audience that stood up and said, no, we think it was always windows, or if it was intended to be doors, but then it was changed to windows, it's been windows long enough and the history of it long enough that those remain what would be historically correct. I think that was articulated by the audience in opposition to the other point of view.
In watching the city council that night on the meeting of the 29th, there were questions even amongst the city council members on whether it was originally doors or windows. So, let's see.
Pardon me for interrupting. I think it was deliberate on the part of the applicant and staff to confuse them on this issue.
So, thank you. Another question I had was, and I've heard different things. I've heard that there was the possibility of a lawsuit by the Ojai Valley Inn because, according to, again, staff report, there was confusion on who submitted the original historic preservation or original request for it to be acknowledged as a historic site within the city of Ojai. And so because there was this confusion put in place on, did the Ojai Valley Inn really agree to it being a historic landmark? And, we don't have any documentation. We sent a letter to the general manager certified, but we never got a copy back. We announced, advertised in the paper 10 days beforehand that there would be a public meeting that that person could come to. They didn't come to the meeting, so then we don't know whether they really disagreed. Two things on that. If you look at, I think, the city council resolution that took place, it says that there was no opposition made by the Ojai Valley Inn. And the second issue they asked, that they inferred, was the fact that the general manager had acknowledged that that this was taking place. However, there was no backup to that was made by whatever organization owned the Ojai Valley Inn at that time, essentially authorizing the general manager to accept that location as a historic landmark. Having seen the plaque that's been on the wall for 2006, I'm pretty sure that the Crown family has been there since 2006. I'm pretty sure that they have, again, these are assumptions, have been in the Neff Lounge since 2006. I'm pretty sure that they have seen the plaque that's outside the Neff Lounge since 2006. So by that, I would think that the Crown family has acknowledged that that is a historic landmark, just by their not raising issues since that was put in place. The second thing goes back to the authority of the general manager at that time. We questioned whether he had the authority to accept that as a historic landmark. However, looking at the city appeal that was filed, this was filed on behalf of Brian Skaggs. Brian Skaggs, if I remember right in his presentation, is the engineering manager. And so my question is, by what right and what authority did the city of Ojai accept an engineering manager's appeal for the decision that was made by the Historic Preservation Commission and by the Planning Commission? Perhaps you can answer that, Mr. Howard.
The appeal can be filed by any aggrieved party, whether or not, we don't know, and I certainly don't know, whether the Ojai Valley Inn designated that individual as the individual to file the appeal. We don't know that, but appeal can be filed by any aggrieved party, and certainly aligned with Ojai Valley Inn. Whether or not they actually nominated him, appointed him, or otherwise, I don't know. But I have to assume that the person was authorized, and that was somewhat reinforced, if not confirmed by the appearance of the Ojai Valley Inn proprietors and their representatives at the city council hearing.
Okay, Mr. Howard, can we then make that same assumption that in 2006, when the Neff Lounge was deemed a historic landmark for the city of Ojai by the general manager, that he had the authority to accept that designation?
Because I don't have any knowledge, either percipient or otherwise, of what happened in 2006, I don't want to misstep, but you've articulated a number of facts that would reflect that they had either the express or the implied authority to accept it. There's enough evidence just from what you've recited tonight that demonstrates that they accepted the historic designation. But I don't want to misstate something that may have occurred in 2006, for which I don't have any information or evidence. But it certainly seems like if he didn't, again, it's been confirmed and ratified by the owners and proprietors of the Ojai Valley Inn.
So then we could deduce from that fact and by that the general manager was most likely authorized to accept the Neff Lounge as a City of Ojai historic landmark, and then also by the resolution of the City Council saying that the applicant had not objected to the designation of the Neff Lounge as a historic landmark, to then accept that as that they were authorized to, and that was done without prejudice.
Mr. Chair, members of the Commission, Commissioner Akins, the second deduction clearly, the resolution speaks for itself, and the resolution is presumed to be accurate and correct. As I indicated before, I cannot deduce. I mean, you can certainly deduce anything you'd like. I certainly can't deduce whether or not the general manager was expressly authorized. But from the evidence and just what I've heard tonight and what's in the record from the past, it would appear that if he wasn't, it was certainly ratified by the owners and or acknowledged at some time after that by the owners.
Great, thank you very much for that.
Can I ask a question on that same?
Sure.
To you, because
Commissioner Walker, your mic's not
my
on.
question is I've looked through the Historic Preservation Code, and to my understanding, there's nothing in there that requires the owner of the building to contribute in any way to the nomination of their building, and there's nothing in the law that requires them to be a part of it. They just have to respond or come and file an objection if the property is declared or nominated as a landmark. Isn't that correct?
Under your code, that is correct.
And
They
then
can
isn't
object.
it also true that the statute of limitations is long past? The statute of limitations is long past, so all of that discussion about whether anything had happened 8 years ago is really irrelevant?
Mr. Chair, members of the commission, in all likelihood, and I never want to say never because of some potential exemptions, but I would say that in all likelihood, the statute of limitations is run. But again, I've seen creative lawyers make creative arguments, and so it's difficult for me to sit here and say, oh, absolutely, statute of limitations is run. It's not going to happen. But in all likelihood, that would be one of the arguments. Again, if it were ever challenged, that would be one of the arguments that the city would raise, among many others.
And the fact that it was a landmark, it had been a landmark for 8 years, the plaque was on the wall and they had never filed an objection. Yeah.
We've heard the evidence. Yeah, I mean, just, again, it's in the record, and like I said, the resolution speaks for itself. They would actually have to try to, reach back to 2006 and saying all this was incorrect, or that there was some real transgression to be able to overcome the defenses that the city would have if the original nomination and designation was ever challenged. Highly unlikely.
Thank you, Commissioner Walker.
Can I also add something to that?
Absolutely.
Commissioner Hill, is your mic on?
Is now.
Thank you.
I've been on this commission for all during the time that the proposal, which started back in 2001, at the remodel of the Ojai Valley Inn. I chaired the commission during some of those years. I remember the situation when it all took place. I remember how vehement this commission was as far as saying, and it's spelled out in the record, and Ms. Wald, you prepared a whole bunch of papers historically over and over again that were reported in the minutes, reported in reports, the vote by the city council, the wording of the report, it's all here. And the record is solid. And one of the things that it said in this record, it names names. And so we do have Singer, that he was the city manager at the time, updated the commission on a recent discussion with the Ojai Valley Inn. Thad Highland supports the idea of historic recognition for the Neff Lounge. He was the director at the Ojai Valley Inn at the time. Robin Sims, who was a commissioner on our Historic Preservation Commission, she had formerly been the director of the Ojai Valley Museum, spent a tenure with us, and then went to the inn as a representative for the inn. And so she managed this whole thing. She navigated the whole project through the inn. And the idea that the Crown family didn't know, or the people at the inn didn't know, that there was a plaque hanging on the wall outside the Neff Lounge, and receiving, it's documented in here about the registered letter that went to the inn. The fact that they didn't respond, the fact that they claimed that they didn't know, that's their problem. It's not the city of Ojai's problem, it's their problem that they're acknowledging. We did everything we were supposed to. And as far as the notion that they felt that the process was faulty, we did, as this commission did, everything by the
by the law, by the ordinances. We got our directions from your predecessor, Kathleen McCann, and she was the liaison, our connection to the city council at the time. And it was very clear in the wording of the resolution that was adopted by the city of Ojai, adopted by the city council, that there would be no further alterations to the Neff Lounge. That was one. And that any alterations to the lounge, should they come up in discussion, should be submitted to this commission 12 months in advance of the time that took place. 12 months. And we had a few days around Christmas and lacking in minutes. It's very interesting when you were talking about the minutes, that the problem was during the delay. As we looked at the minutes online, we noticed in the audience that night, there were no minutes for the Ojai Historic Preservation Commission since March of the preceding year. All those from April all the way through December were missing. And that wasn't because of a family vacation at Christmas time.
Okay, don't misspeak what I said. I didn't say because of some family vacation. I said that staff was directed to do them and they didn't get done. I'm very clear about that.
Yes, but what
Okay,
about
second of all,
April's-
just to let me finish, Rhonda Basler, the city clerk, is responsible for putting those up. It has nothing to do with me or my staff. My staff gets them signed and they go to the city clerk. I know this has been confusing for many people have brought this up now. Nobody in my staff has the responsibility for posting minutes. They go to the city clerk. Once they're given to the city, they have a process they go through, and she was directed by the city manager to make sure they're all current now. So that wasn't deliberate by anybody in the HPC staff.
Well, the Ojai Valley Inn took up that cause, and they were reciting that they had no evidence of minutes of what we had been doing in regards to this process.
I'm sorry, I don't
See,
really.
they operated in a vacuum. They operated under the guise of ignorance. They said, we don't know the plaques there. We don't know when it was put up. We never got the letter. On and on and on. A lot of these things were not true. And when we were faced with this, outside of the 12-month designated amount of time that we were supposed to have to respond, it made our position horrible. We walk into the meeting that night, that whole side of the room was filled with reserved seats only. We couldn't even sit on that side of the room. We were secluded over there on that side. And Craig and Darwin got up and did a remarkable job in the short period of time they had to try to tell our side of the story. And it wasn't fair. It absolutely wasn't fair. We should have had our 12 months of time to react and interact. Now, this is, wait a minute, let me just finish this. Whenever we have a project, the person comes before our commission, they tell about their project. We have a historic report, which we didn't have initially, and we also have their best shot. And then we say, well, this and this and this, and you can't do that, you can't do this, or you can do this, or maybe we can make some modifications, make some changes. And a lot of times, there's a back and forth. And the architect takes our ideas and comes up with a new plan. And the back and forth occurs until we get something that can be agreed upon, or it can't be agreed upon. Now, had the 12 months been spent, and at that time we were at a impasse, then I can see the inn wanting to do an appeal. But to do it within the 20 some odd days that this whole process took place, that's wrong. That simply is wrong.
All I was going to offer is that, I know you're just making a statement, but would you like Mr. Howard here to speak to the 12 months?
Sure.
I guess that's all I was going to offer. All right.
it. I'm actually checking the resolution because we
I have it right here if you want to read it.
well, we're talking about either the resolution or the ordinance.
Both. Here they are, right here.
I'm prepared to make my comments relative to the ordinance, and actually, I was looking at the resolution because I don't recall seeing that.
It's not
In the resolution, it was-
in the one that they did.
Here's the
This is the
administrator.
designation of the inn. Well, in any event, the 12-month rule by ordinance, frankly, I find puzzling. I'm not certain what the rational relationship is. Where it's placed in the code seems to suggest that it was intended, and this is not easy because it is, in my view, vague and somewhat poorly drafted and poorly placed in the code. That 12-month rule requires that someone who is planning to make an alteration to a historic or cultural resource provide notice to the Historic Preservation Commission. That's all it says. It doesn't say that they should engage in dialogue. It doesn't say that they should engage in filing an application or hearing. It just provides some kind of notice. It's frankly almost punitive to provide that kind of lead time for someone who to merely submit a vague plan that they may be doing something in the future. For the work permit provisions, which was the code provisions that were utilized to, or relied upon to file this application was the work permit provisions of the code. Under those provisions, there are requirements that an application be filed, be referred to the Historic Preservation Commission, where I believe that's where the give and take would occur at a public hearing. You might send them back, you might reject it and ask for more information or new information, at which time, if potentially it's not resolved, it can be appealed to the City Council. I'm not sure, and we could not find, in the short period that we were able to review, any legislative history on that section that was adopted in the 1990s related to that 12-month rule. I just could not find it. So we cannot come to any conclusion as to what the legislative intent was. And frankly, to require a 12-month, to require an applicant or someone who's not even an applicant but may have a plan for any historic resource, for any alteration to a historic resource to submit just a notice, I'm not sure passes the rational relationship test that a court would utilize in examining whether or not there's a rational relationship to any legitimate governmental goals.
Thank you. Commissioner Walker?
Yeah, if we could turn to the 4.808, first of all, number I on 4.8.08. That's under report and recommendation of the Historic Preservation Commission, 4.8.08. On the back side of that sheet under I, this is where it says there's an interim prohibition, and this one is separate from the one we're referring to. It says from the time this commission nominates, there's a 90-day period in which the council can make a decision, and can be no defacing, demolishing, adding to, altered, or anything between that time it's nominated and it's declared. Then you go to 4.8.09, which is titled Declaration of Landmarks. Okay, this is when they're declared. It says, if the conclusion of the council is that a landmark or point of historic interest does exist, the property owner shall be prohibited from defacing, demolishing, adding to, altering, moving it without having given 12 months' notice to the Historic Preservation Commission that such action is planned. And on the memo that Monty Witters, the former attorney, gave, he gave a memo to Rob Clark about some proposed historic action that was going to take, and he reviews the Historic Preservation Ordinance, and he says under E, if the city council declares the property a landmark, The owner may not alter or demolish the property without giving the Historic Preservation Commission 12 months' notice prior to such action. I'm not sure it really is that punitive, because we've seen the consequences here with this decision of what a rush job can do. It is a major thing. I think those who crafted the law wanted it to be a major decision. You may know that under the Mills Act, if someone decides they don't want to be in the Mills Act anymore, they have to give 10 years' notice.
10-year contract.
It's a 10-year contract. And so there's good reason for that, because they want this to be a slow, deliberative process. And so I'm not sure how you can interpret this in 8.09 any differently than if you want to alter. Now, if you want to make an addition, it doesn't have addition here. So if you wanted to add an outhouse or add something, that's not covered. But if you want to deface it, you want to demolish it, you want to do anything like that to it, you need to give the 12 months notice. And isn't that what it says? And isn't that what Monty Witters, who crafted the language, says it means?
Mr. Chair, members of the commission, I don't know if Mr. Witters crafted that language. From what I could see, the ordinance was adopted in the 1990s. He may have. That memo you're speaking of is not an opinion on the interpretation of this section. That memo is an opinion on whether or not doing a survey of historic resources creates a necessity for an EIR. All he did was recite the language of the Historic Preservation Ordinance in more summary format.
Right.
Did not analyze the meaning, the location, the context, the form, or any of the legal implications either under the Constitution or state law that may implicate whether or not that 12-month period, what was intended to be said, what it was intended to be meant, and likewise whether it would withstand scrutiny if challenged. So that opinion, in my view, may be an excellent opinion on the points that it was trying to address, and that is whether or not CEQA requires an EIR if you do a historic survey, but it doesn't address the issue that we're addressing now, and that is the interpretation of that 12-month rule.
But the issue we're addressing now is what is there in this law that prevents just what happened by something being rushed through where it's not given proper review and a landmark. We're not talking about just an old building or an interesting old house. We're talking about one of our 20 landmarks in the city limits.
Understood, and completely respect that. The problem is I'm focusing strictly on the legal interpretation of that language. That language doesn't accomplish that goal because there is nothing in that provision that provides for anything other than notice, period. It doesn't say there shall be notice and it will start a process of some sort. It doesn't. It just says notice, which means if I interpret it consistent with the language that's there, I can send a written memorandum or literally one line to the Preservation Commission. I'm at such and such an address. I'm planning to possibly change this location, or it's a historic monument number X, and I'm planning on making some alterations in the next 12 months. Here's notice, period.
Well, there's another point in here where it defines demolition as demolition in part or in whole. And then it says, so it would be a demolition of some part of the landmark. And then it says that if the commission so desires, if there is a request for a demolition permit, that they can request 6 months' time to be able to negotiate with the owner of that property over that. We were not given the option. There was a demolition permit that was granted to the Ojai Valley Inn. At that meeting, we were never even given that as an option, that we could negotiate with them for 6 months.
And Mr. Chair, members of the commission, Commissioner Walker, excellent point. Different issue, however, and we can address that as well. But focusing on the 12-month rule, you again reinforce the point that there are other code provisions that address in reasonable fashion that actually, just by reading the language, you can understand why it's there, the goals that it's trying to achieve, and the purpose. This one, frankly, is this dangling section that really, I was trying to make heads or tails out of it, searching for anything that would give me the basis to sit here tonight and opine that, okay, it's 12, you got to submit a notice. But when you're looking at whether or not something is going to withstand scrutiny, you look at what they call a rational basis test. Is there any rational basis based on legitimate governmental goals that you're trying to reach for upholding this kind of provision? I couldn't put my finger on one, except perhaps where after a designation occurs, immediately thereafter, if someone is an angry, let's say they were an objector and they're somewhat angry that their property was designated as a landmark, there'd be a 12-month cooling off period. But I honestly have difficulty with that. And so it's difficult for me without finding some sort of legislative history to determine that there was a legitimate governmental reason for this dangling notice requirement that does nothing more than say notice. If it had language, for example, that you just read about the demolition, where there's a 6-month period for negotiation and discussion, I may be troubled, frankly, by the length of time, but I'd be a lot more comfortable with the fact that there was a purpose behind it. There's nothing. There's nothing. Getting to your other point, and that is, we didn't even get the benefit of, whether it's 12 months or 6 months or any other provision in the code that provides us, we didn't get the benefit of that. That may be true. That may be true, and that may be an irregularity. But it may be an irregularity, and that's the way the courts describe it, as an irregularity. And if it's irregularity like that, what the courts do is to try to determine, was there any prejudice? And the prejudice meaning, the people, did they not get notice? Were they not aware of this? What happened that so deprived these individuals of an opportunity to address their legislative body, or in this case, the commission, that they would that there would be a likelihood of a different result? And that would be the test you would look at for an irregularity like that. I can't speak to whether or not any kind of notices were given, because it's something I don't know.
Can I ask you this one question then? Since you are saying that this dangling qualification of the time, is this going to be an impediment to every other historic landmark we have in this city?
Mr. Chair, members of the commission, I'm not sure I would describe it as an impediment. You may, and others may. I would suggest that it be amended. And whether, to be clear, what the intent of the city is in requiring some kind of a lengthy period for some kind of notice. Not just notice, but notice and an opportunity for then the commission to start a process to meet with an applicant, so you can go through the give and take, as Commissioner Walker mentioned, and that I think that you've mentioned yourself was something that can be very productive. Right now, it stands there as just a 12-month notice, period. I would have loved to have found something else in the code that would relate back to that would start a process, but there isn't any. And the concern when I see something like that is that, what would then happen if you get notice? Are you going to put it on the agenda and begin discussing the matter without giving the applicant an opportunity? Is there going to be some potential substantive or procedural due process concerns? I find it somewhat troubling. It's a very unique provision, in my view, without having any kind of basis for it other than just give us notice.
But you can imagine being in our spot to get 6 or 7 days before a meeting where a landmark is going to be altered in the way that it was, and having in that short of a time to discuss it, go find the local historians, go into the museum's library, look up pictures, do all of that. There was no opportunity for us to do that, and that's what I feel, that it starts us thinking, it starts the whole process, and also it's a cooling off time for the applicant to say, do I really want to alter this building when I know that there's going to be this lead time that I have to give the notice, that I can't just push it through at the last minute.
Mr. Chair, members of the commission, an excellent point, and I think one that deserves discussion with your city council in an upcoming joint meeting about what kind of process would you like to see as part of a notice requirement, whether it be 12, again, I have concerns about 12 months, but let's say, for just sake of discussion here, 6 months. If that were reasonable, what type of process would you like that to be? Because right now, other than the demolition permit and other than the timeout provision while something is pending, it's not there. And I think that would be a good springboard for that discussion.
Thank you.
Can I ask two?
We interrupted Commissioner Akins about
Right.
15 minutes ago.
Thank you, Commissioner Aiken.
That's okay. Gave me a rest. Just, I think, one final question to Ms. Wold. Again, in your report, it seemed to infer in that report that when the process was done for the landmarking the Neff Lounge with the city of Ojai, the inference was that all of that work was done by a Historic Preservation Commission member, Therefore, the question was raised in the information that we have. Well, did the Ojai Valley Inn really have a chance to express their opinion, either positive or negative? Looking in your report, attachment E, page 2 of 41, it says, in accordance with the final environmental impact report, FEIR, the inn submitted an application for landmarking consideration for the Neff Pierpont segments of the Hacienda building. That's also mentioned in other places. That seems to indicate to me that the inn submitted that, not just a historic preservation committee member, and that therefore they did have input into their being recognized as a landmark with the city of Ojai.
Do you want me to respond to that?
If you would, please.
So I don't know what inferred means, just so that you know how this process works, it's two parties, it's the Neff Lounge and the rules and regulations and what the HPC and what the PC said. Very clearly, the applicants had a long meeting with staff and indicated that the process was flawed. I didn't bring this up, they brought it up. Those things are mentioned in the staff report, and all that supporting evidence is put into the staff report so that a person who's a decision maker, council people, can look at what the applicant's saying and what the staff has provided as documentation. Had I not provided it in the staff report, what they were indicating, they asked us very clearly, send the application I signed. There was not one. Show us where we attended a meeting. There was not any minutes that said anybody attended. Show us where we signed that my general manager could do this. It wasn't in the record. Clearly, that's all I'm trying to state in there. Those things were all asked by the inn, the Crown family, for us to document. Send those to my attorneys. I would like to see them. They're not in the record, and that's clearly all that is indicated in the staff report, is that all these things these were the things that we could not find to provide for you. If they were there, they would have been part of the staff report, but they're not there. There isn't a signature. There isn't an application. There isn't a receipt. When you send an item through the U.S. Post Office and you send it return receipt, a person receives the letter, that green part comes back to you. That's not in the file. They asked for it. It's not there. I had to factually put those things in the staff report. I didn't think it was anything other than facts of what I was asked to demonstrate and provide copies for the applicant, and could not. That's clearly all that was there. They were required by law, and Mr. Howard can speak to this, to apply for landmark status. According to the city attorney, and not Mr. Howard, Mr. Fletcher, it is against the law for you to require them to be landmarked. They're only required to apply. That's all they were required. So I could never find an application. Yes, you could infer that because the process was initiated, the process went on for 2-3 years. I mean, it was a long, drawn-out process. It wasn't short. So all I'm trying to do is provide the facts, provide an aggregate of the administrative record. Decision makers take all that information into account, and they made their decision. But clearly, I couldn't provide those things the applicant asked me to provide for them. That's all I'm trying to demonstrate in the staff report.
What is the date of the application for the permit application?
For the work permit?
Yes.
I don't know. I'd have to look it up.
You don't know?
No, not offhand. No, I don't.
What was the date of the meeting with the attorneys for the inn
What meeting?
that you just referred to when you met with the attorneys for the
I see.
inn regarding the issue of the application for
I don't
landmark
know.
status?
I'd have to go back to my desk and look at those things. I don't know. It was, in November or December. I don't really know. Does that surprise you? I mean, you're looking at
Yes,
me
it does
quick.
surprise me because of the speed with which this is all processed. I would think, it's so recent that you would know because it was all in this small.
So just so you know, I work approximately, 12, 13-hour days. I work on all kinds of things. This isn't the only thing I was working on.
I'm not accusing you of not working hard. Thank you.
No, I'm not.
Thank
I'm
you.
not. I have no idea. I'd be happy to find that for you and bring it back to the next meeting, but I don't know when we talk to him.
I'm simply saying that to act like this application was handled as business per usual in this city is preposterous. Please don't interrupt me.
That's fine.
If I were to go to the clerk with a roll of drawings and a permit application and go, I need this in 3 weeks, do you know what she would say to me? And please don't answer. She wouldn't say anything. She would laugh at me. This is preposterous that this proceeded in this way. That don't try to tell me this was business as usual.
I never said that. I don't know in what words I used that you said that you think I said it was business as usual. I've not indicated that in anything that I've done. I have worked long hours. I have worked Saturdays. I understand exactly where you're going with this. I have never indicated to anybody that this was business as usual. This was an expedited. I even indicated that to you, Chair, when I asked if we could have a special meeting, and I sent out an invite to see if people were available, that it was a special meeting. It was asked for on the spur of the moment. Everyone has not acknowledged that from the very get-go. This wasn't anything that as I initiated to have a special meeting, and I have never indicated to any of you that it was business as usual. It was a special meeting. It was a short time frame. And I indicated that to everybody when I asked if they could attend.
Commissioner Walker?
I'm
sorry, Commissioner Akins?
One final question for Mr. Howard. We've sat through meetings annually on the Brown Act. At the beginning of the meeting, I think the city attorney, or perhaps I think it was the city attorney, asked the council members to please disclose if they had had discussions with any of the parties involved in this. 2 council members mentioned that they had, 2 out of 5. My understanding from talking with different people since then is that every council member met with the Crown family, Steve Crown, I believe he was the only one here. So instead of having, and 3 is a majority on the 5-member council, is there a conflict? Is there a Brown Act conflict in having the city council members go and meet with the applicant, each and every one of the city council members?
Mr. Chair, members of the commission, I can't speak to whether there's a Brown Act violation because I don't know, potential Brown Act violation because I don't know what those conversations were. The reason for disclosing ex-party contacts is primarily so that in quasi-judicial hearings, such as the Ojai Valley Inn, you don't have decisions made by evidence not of the record. And so if you disclose those ex-party contacts, yes, I met with so-and-so, and maybe we talked about something, or maybe it's even in a shorter format, that's disclosed for the record, it's out there. That's the main purpose for doing that. Brown Act violation occurs if there's a potential seriatim meeting where the council members, if they meet one-on-one, for example, with a constituent, they talk with the constituent about a particular project, that constituent then conveys a council member's feelings on that project to the next council member. Then when you get beyond 2, that's when it becomes a potential problem. It's not a Brown Act violation just for that to happen. It's a potential Brown Act violation if how a council member may vote or how they would deliberate on a particular item gets passed beyond the 2 council members of a 5-member council. So I couldn't say if there was any potential Brown Act violation.
Okay, thank you. Is it an issue in the request that was made by the city attorney for all council members to disclose whether they had discussions with the applicant, and only 2 out of 5 disclosed that? Is that an issue?
That's more of an issue of whether individuals are candid in whether they had contact with anybody and what they may have said. It's not a legal issue, but it may be an issue in terms of how you view commissioners and council members in terms of their candor. Again, they could have forgotten, they could have been mistaken. I don't know, and I don't want to put words in anybody's mouth or make any misstatements, but it is not a legal issue.
Okay, thank you. And in conclusion, I just want to thank you, Ms. Wold, for the voluminous paper. I'm pretty good about going through and proofreading contracts and technical documents, and it was a journey. There was information overload here, so I appreciate that, and I'm sure we all recognize that it wasn't you that was voting that night. It was the city council members doing that vote. The responsibility for their vote lies solely with them. If they were misinformed in some way, or if they, not that I'm inferring that to you or putting that on you, then that's their responsibility to seek out the facts and to verify the facts. So again, I thank you very much for all of your efforts in preparing this for us.
And I will just say, from my viewpoint, that the materials that were presented, I don't like, that's not how I normally do my work. normally have things coming in at the last minute. I don't. I like to have things well documented and available for the bodies that I work for. And, you know, it was very difficult to bring that forward with the kind of things coming in. I mean, for instance, there was an artist rendering that you guys didn't see, but the council saw, you know, the information presented. Because it was a de novo hearing, they could do that. But that's not normally how I would operate either. And so I just wanted to you know, make it very clear that, you know, that's part of what happens when something is rushed. And so I acknowledge that too.
Thank you.
I had a couple of other questions about the process. This one is about the CEQA exemption. And I had talked with Sean DeCourcy up at the Office of Historic Preservation, and he's talked to you as well. And he said to me that he thought it was highly irregular that a CEQA exemption would be given to a project like this because it was a historic landmark. It was clearly historic property. There was considerable damage or change that was being proposed for that. The landmarking of the building itself was part of a mitigation that was from a EIR that was made some years before. And I just was wondering, under what conditions would a historic building not get a CEQA exemption? Under what situation would you require that it go through the CEQA process? It seems like this would be a good example of one.
So I think the staff report that I gave to the HPC and the PC, that I made it very clear under what findings they'd have to make in order to make a CEQA determination, and you along with the Planning Commission could not make that. So it is ultimately a decision maker's responsibility to look at the evidence that's provided for them into the record. I mean, obviously that it was very clear if you found that altering that wall was a part of the, if you could make the nexus between altering that wall and that wall specifically being one of the elements that it got landmarked for, so there is kind of some interconnectivity and direct impact to one another decisions that are being made. For instance, you all felt that that wall was an integral part of why it was landmarked and that it shouldn't be removed. And so it was easy for you to make the determination that it did not qualify for a CEQA exemption. And that's what you did. So it's very clear that you made, it's just a difference of opinion between one decision-making body and another. The evidence was put out before them, and you looked at that evidence and you made one decision, and they looked at the evidence and made a separate decision. Same dialogue.
But you made the recommendation that it be granted, that the exemption be granted. You made that recommendation.
No, I didn't. No, I didn't. I laid out the recommendation that if you made the following findings, I do not make those findings for them. If you can make this finding, if you find that removing that wall is not substantial, I didn't make that finding for them. It was a very loose presentation of how they could get entitled. You know, it was, if normally under most circumstances with a CEQA exemption, we say, we find because of this, it was very clearly spelled out in the staff report that in order to make the findings for, I mean, it might have been under the recommendation that if you make the finding, to make a category exemption, if that's what you're going to do, and you're right, in that case, it was my recommendation, but in the body of the staff report, it was very clear, and you weren't able to do it. And neither was the Planning Commission. But I laid out what they had, the pathway they had, the decision-making that they had to make to get themselves to the point that they could do a CAT exempt.
But you say that we couldn't make that finding, but we did make that
No,
finding.
you made the finding that it wasn't exempt.
Right.
That's what I'm saying. You made that finding with the same evidence.
But why
that
wasn't
they-
that finding presented to the council? That's what I don't understand. Why
You-
wasn't
it
that?
was. You got-
No, it wasn't.
No, it was not.
Well, I don't know what you were expecting.
It didn't spell out, it says in the preservation ordinance that
Mm-hmm.
the findings of the commission will be put in writing, and yet none of those findings were passed along to the council.
Right, and again, that gets into that the intent of the presentation of the packet to the council was, well, I don't know what, I don't know what to say about this, because, you know, obviously it would have been better if there were minutes, and there would have been better if the resolution had gone along with it. Those,
Even not the minutes, but just your report stating the findings. As you stated the findings of the Ojai Valley Inn, you stated your own
Very well.
Okay.
but you never stated the findings. But, okay, let me
So
go on.
I just want to make sure that you all know that at some point, I'm not going to offer this as an excuse. And he's already took me to task for taking a family vacation, but I made it very clear to everybody that I was leaving, okay? So this report has my name on it. 3 other people had authorship to it because I wasn't here. I left on the 19th. Okay, and so I want to make very clear that you guys can all take me to task for this and burn me at the stake if you like, but I was not the sole author of that report, and I apologize that your minutes were not into that report. I was not even in the state to do it.
Well, I think it just raises a lot of questions. Like, my next point was that when the head attorney for the Ojai Valley Inn got up at the 29th meeting, he introduced the architectural historian, Mr. Stone, as part of his team. And he said he will speak when I ask him to speak, is what he said. And
I don't
I'm
remember
wondering,
the way.
does the architectural historian that writes these reports, are they part of the team of the applicant, or are they here for the city to give us the information we need to make a rational decision about this?
So are you asking me, so the historic past practice of the city of Ojai is that in every case that an expert is used, whether it be an archaeologist or a historian or a hazmat person, someone doing a phase 1, they're always hired by the applicant. That is the way the city of Ojai has always done it in every aspect where, you know, since I've been here, I have had some reports peer reviewed. Because that is the way it's always been done here. There's never been at arm's length. And if the city wanted to establish that policy, is it a good policy? Yes, it's a good policy for for them to put the money into an escrow account and for us to hire them.
Yeah.
That is the way I'm used to it where I've worked before. That is not past practice here, never has been.
All right,
And
well,
so,
that's a good point. We
so-
learn something every
right.
meeting,
So in one case, even with the arborists that do the arborist reports here in the city of Ojai, the applicant hires them. If in this case, you're right, and, you know, just so that you know, Mr. Stone, he's not happy with me because I made him be out. I mean, I have just as much angst from him as I do from you because I made him be out there when they were doing the demolition and stand watch over what they were doing, and he was very much adverse to doing that. And you know, I told him, I said, this is not going to be a slippery slope. Somebody is going to be out there the entire time. I do not want to go back to my commissioners and say, oh, by the way, this is gone and this is gone and this is gone because we got into it, okay? And he was very clear with me that I was being outrageous. So as much as you are on this side, I'm getting it on this side too. And I'm telling you, the walls were marked. They were marked in Spanish. Everything, we held them to the T of what they were approved by the city council to do. But, you know, I do agree that we should require deposit of money and hire somebody. And like I spoke to one of you, or maybe it was Sean at the state, what I'm used to is you have at least 3, you have them on a list, and you rotate them through. So no one ever knows what project they're getting. So they can never form a relationship, they can never curry favor, because it's kind of like police rotation. This tow truck, this tow truck, this tow truck, you know, oh, who's next on the list? And they just come up like that. So there's never the same person doing report, oh, you know, hey, who will give me a good report, you know? No, it's always a rotation.
Because one of the things that bothered me about his report, as well as, I guess it was reflected in the staff report, where they kept saying that this wall was not original. And that made it sound like, well, it was some addition that was made later. But his report never called out the distinction between somebody adding something unoriginal on and a restoration. And a lot of this unoriginal work was restorations, which is clearly in the Secretary of the Interior standards as being a proper treatment for historic landmarks, is to restore those. So to say, well, that wall or that pillar wasn't original, so it's okay if we tear it down. That doesn't really follow if it's a restoration. That's part of the landmark. If you made that a requirement that it all be absolutely original material, there would be no landmarks in America.
That's right.
Because they have to do some restoration on these buildings. But just because it isn't the original wood or the original lath or whatever in there doesn't mean that it's not something that is every bit as worthy of being preserved as the original material. And so that was one point. That report
sorry.
didn't really call that out. Another thing was
Are you talking about his report?
his report,
Right, okay.
on his report. And then another point was that whether or not they could do alterations, and I didn't see any distinction between making an alteration and compatibility with the historic. One of the central points of the Secretary of the Interior standards that we all try to follow is that any alteration that's made must be compatible with the historic and architectural nature of the building. And one of the points we kept trying to make is that tearing out that wall and making this open floor plan with the bar wasn't a compatible alteration. Even assuming you were it fit within the notice requirements and all of that, it would not be something that we would want to approve if it doesn't preserve the historic look and the compatibility. But I didn't see any discussion of that. It was just like, well, it's okay for them to make this alteration, but you have to look at the compatibility too of what you're doing. You can't just do anything just because
Well, I find it, I mean, just so that you know, I find it a little bit difficult too that, kind of like the Ojai Valley School, that once a report is written and then they get into the actual work, that it's kind of a slippery slope too. So my concern.
That's not the point here, I think.
No,
I think
no.
the point here is why weren't more of the comments of this commission written into the report? Why weren't they woven into it like everything that you took from the applicant?
And I felt bad
I mean,
because
that's clearly,
the council
we were clearly
kept saying,
ignored.
the council kept saying, well, you have to be able to allow some changes. There's adaptive reuse. And of course there is. This commission accepts adaptive reuse all the time. The museum, like you pointed out, the old firehouse, this new Maravilla Realty company that they want to make a landmark. We're very much for adaptive reuse. But it has to be compatible. That's the point. So there was, I think the council got this impression that we were saying that things couldn't change at all. And that's not what we're all about. And I don't want anyone out there in the public who has a historic building to think that that's what, because we are very supportive of like the people at the firehouse making it into a wine tasting place. We love that idea, you know, give it a new use, the place looks the same. We've even had owners of historic homes that say, you know, my old kitchen needs, fine, just make it compatible. Show us your plans, let's all make sure we're agreed that it kind of fits the historic style, and we're good with that. So again, I just felt that the council kind of got the feeling that we were saying that there couldn't be any changes.
So I will make this very clear. When I left and I had this report and I talked to the city manager and I talked to them on the phone, I was under the impression that the packet was going out with your resolution, with your findings in it, and the minutes. I did not know that it didn't have that until I returned back on the 28th or 29th, and I did take it to task with my staff. So I didn't intend for it to ever go out without, I would never do that to my commissions. Did not intend to slant the report. It was intended, and I had given direction, and I had been on the phone with everybody, and I intended for it to go through with your comments as well as planning commissions, those both resolutions and the minutes from those meetings. So I get left direction specifically to have the minutes prepared for the packet, mark them draft. That didn't happen. That's my apologies. But at the point that I found out was, I think probably, well, I don't know, maybe it was the morning of the meeting, or I don't really know at this point, because city council would have been, was a special meeting on Monday or Tuesday? Does anybody remember?
Monday.
Oh, Monday. Okay, so I found out that day, and I pulled them up to put them on the dais, and there was nothing there. They weren't even completed. It wasn't even, it wasn't even as if it was a mistake that they weren't included. They weren't compiled. So there was, at that point, nothing I could do. And I was very clear and told the city manager what the issue was.
But I
And
think
and I did talk to Mr. Councilman Wyrick, and I told him, you know, I don't have minutes. There were people that asked for minutes, and I said the best I could offer to you is that you watch the YouTube video of it, and that's the best I could
I think
offer.
the bottom line is we just have to insist that a project not go through this quickly, because all of these problems came up simply because of that. And even after the fact, we learned that a couple of the council people went up and noticed that the drawings weren't the same as what they had approved, and we're trying some last-minute 11th-hour negotiations, and it's just not the way to do historic preservation. I think
No,
that's
it's
why
not.
we need that long process where it has to be thoughtful. The owner has to say, look, I'm thinking of making a change to my landmark, and this is what I'm going to come up with. I think that's the bottom line for me, is that a lot could be avoided.
Are there other commissioner comments?
I have,
Commissioner Hill?
Yes, I had one other, and this is kind of like the, now that it's all been done, point. In the plan, the architect said that they had planned, or they are planning on an interpretive display to exalt Wallace Neff, or whatever the plan is. I would like to know who is going to do this interpreted display. Are we going to leave it to the Crown family, who didn't know that the Wallace Neff plaque was hanging on the outside of the building? Or are we going to assume that responsibility?
All right. Thank you for that question. So my understanding is it's Mitch Stone from the San Juan
Which is going to?
Ventura Historics Consultants. I would be happy to, I think the HPC should be involved in that. And I think it's the least that can be done at this point is to make sure that you're involved in that. And I'd be happy to reach out to either the representative of the Inn or Mr. Crown himself and request that. But that was my understanding. And you know, we were very insistent during this whole process, as much as it was a difficult decision for council to make, that they not do anything beyond what was approved, that there be photographs taken and documentation of it. You have some photographs in there, and and we wanted a historian out there during all demo activities to make sure it didn't go beyond what was approved. And we're hoping that there's a pretty complete report of what they did and what they found when they were there. And just so you know, so an update is, you know, again, I was pretty clear with them, and I know Diana and I both went out there about, you know, they represented over and over and over again that they would not touch the ceiling. That was very clear that night. They said that. And so even the beam, there's two beams that have corbels underneath and one that went all the way across, kind of defined the lower ceiling from the vaulted ceiling. We were very clear that they were going to take it down and reskin it. We were absolutely not. It stays just the way it is, and they're going to scab on a piece onto it, you know. So we were very clear all along of not allowing them to do anything more and not have it go further than what was approved. One time they felt that they were going to remove the north pillar. You know, there were two pillars that held up that big beam that went between the two ceilings, if you understand what I'm talking about.
Yes.
We were like, absolutely not. You will not take the north down. You are not entitled to do that, and you cannot do that. And so
Well, wasn't this work represented in the permit application documents?
Well, see, I think that gets back to the same point you've all been making, is that you know, because somewhat the language and the agreement that came out of the verbal testimony was somewhat disconnected to what was submitted, because it was evolving during the meeting. If you remember, if you were there at City Council, one of the things that came up was vault the ceiling again, vault the ceiling that's dropped, and they were saying, no, they found out that the dropped was original. Do you remember that all fleshing out at the meeting? All that stuff was then getting reviewed and approved at
And
the
those
meeting.
changes need to come back to us.
Well, that's
And
what I
that,
said.
that was one of the things that happened that night. When we went into that meeting, the applicant said, we've made revisions, we've made alterations. When it became clear to them that they would have to come back to HPC, they started huddling in the audience, and then they came forward and said, no, there are no changes, because they didn't want to come back to us. Oh, you're absolutely right. Things were happening on the fly. You're absolutely right.
And so I wanted to make this very clear that staff's understanding was they could open the south wall up and they could change those windows to doors, period, end of story, nothing else. And we've held them to that. You have pictures in here that show that that's what it's like. We've had them taking pictures. You should get a report back from either Judy or Mitch, and they are the ones working, as from my understand, on the interpretive plan. But I would like it to come back here and you guys to have a say in it, so I will reach out to them if you'd like me to.
Well, just one thing I wanted just to build on what you said about the interpretive plan, because the architectural historian said it's likely that no one that walks through that lounge knows that it's a Neff lounge or knows anything about it or any of its history. And they said, and nobody uses the lounge. But after we tear it apart, then we're going to tell them what the lounge's history was. And we're going to tell them all this stuff about it. And I thought, well, maybe if they hung some pictures of Jane Mansfield on the wall with the flying tigers and had like Bob Hope's golf club up there on the wall and had it represent that history, maybe people would have used it as it was and they didn't need to make it into this extension of their bar.
Yes, I agreed. I think that makes sense.
I was hoping that perhaps in the plan would be a 6-foot bronze statue of Wallace Neff in the Neff Garden.
I didn't get an answer from you folks. Would you like me to reach out to them and ask it to come back and you have a say in the interpretive plan?
Yeah, I think it's
Sure.
Well, they have to come back
Well, for what?
for all the changes to the lounge. They have to,
They-
for
they
the
ha-
terms of the landmarking agreement.
Okay, so explain to me what you're
We
specifically.
have seen no detailed design work from them. When we approve changes to a landmark interior, we see very detailed drawings, and we have not seen that. Things are changing, as you say. So how can we approve anything?
Do you want to speak to that?
I'd like to tell you that,
The attorney.
oh, I'm sorry.
Well, I was going to say, I'm not sure I completely understand it. This project was approved by the city council with conditions, and I assume there's a whole host of conditions that were required of the developer or the applicant, and it's those conditions that are going to be complied with, as I understand, to a T.
So,
Commissioner Boggs?
you asked about when the work permit application was made. According to the resolution, it was submitted on November 12th, 2014, for the work permit 1401.
Thank you. So the permit came in 3 weeks before the Historic Preservation Commission was notified that it was coming to us. Are there any other comments from commissioners? Commissioner Akins?
Just one quick thing. Again, I want to thank you for insisting on Mr. Stone's follow-up and pictures. When I was going through the package and I got to the pleasant surprise in the back to see the actual work and see photographs of the work, exposing that's the lath wood structure that's in there. Once that plaster was removed forever, so that we could see what was taking place and what was being done. That was very helpful, because we've seen how when that's not done on some other projects, things just seem to change. So I appreciate that very much, you're following up with Mr. Stone on that.
Can I,
Commissioner Hill?
in regard to those, can I ask a question about the interior of Neff Lounge? And I think this is in reference to what Commissioner Akins was talking about. It says the interior of Neff Lounge, January 15, 2015. It shows doors in there. Now, I haven't been up there. Now, is this a Photoshop or is this, it's a Photoshop job?
No, which one? Show me.
Interior Neff
No,
Lounge.
no, that's real doors.
Doors are in.
Yes, and let me see if I can get to the same page you are. So we were called out there, I went out and there should be photographs also of, so they didn't remove any of the plaster from the window to the bottom of the window. It was only removed from the bottom of the window down, I should say. And when they removed those windows, it had plywood in the framing materials. So again, we're going to go back to the same thing that I know that bothers Commissioner Walker. They weren't, or Vice Chair, they were not evidently original windows, but the stucco wasn't disturbed, only down below. So it was pretty minimal. And they actually had the header and the plate there, did they not, Diana?
That's correct.
That was my understanding, that it had a header for a door already in it. So they didn't disturb any of that plaster from the window. So it was, and I haven't received this documentation, but what I was told out at the site was there was a header and a plate. Ergo was originally designed for a door, and, I'm still waiting. I mean, I'll take that with a grain of salt until I actually get the report in, but I'm only reporting back to you what was said to me. And so then on the next page, the last page, this is the temporary wall that they put up inside the Neff Lounge to separate the Neff Lounge from the Maravilla restaurant while they continue to do work. So you're seeing this gentleman standing in front of it, this one right here?
Mr. King?
Yes.
The managing director.
The new, yes. That wall is a false wall that you're seeing there. That is the south wall. It's that, so in the previous pictures, you're seeing it removed, and now you're seeing it back. That is what it, so you can see the beams without the corbels underneath them. And then you can see right above his head, you can see where we made them keep the, okay, so let me see if I can describe this well. Okay, so there's two beams in the picture. The first one should have a corbel underneath it. It's missing because of construction. The second one is the one that went from one pillar over the other pillar, and you can see where it's a little bit skinnier right there. That's because we made them retain the original beam, and they will scab on a piece. So this is to document how it was left. But I just want to make sure you understood that wall there is just kind of a faux wall for a temporary occupancy so they can continue to work on the Neff again. I haven't been out there this week. I don't know if they've refinished the floor. I will tell you that they talked to me about, if you go into the lobby, this type of ceiling is replicated in the lobby. It's new and a replica. And they have stained that dark now, and they asked me, the Crowns were there the day I was there, just happened to be, if they could do that dark, and I'm like, again, you cannot touch the ceiling, okay? So, and I told them very clearly, if they wanted to touch the ceiling, it's another historic report, and it's back to you folks.
Clearly, they just don't get it, because the doors that they've added on the wall on either side of the fireplace don't match the doors that they've illustrated in their application document. So here we go, and they think they can stain the beam, so they don't understand. This applicant still is unclear on the concept.
And so staff continues to go out there, we continue to monitor them, and I continue to reiterate the same thing over and over and over again to them. So I'm doing my best. What is with the doors?
All kind of points up the importance of a 1-year rule or a 6-month rule.
Right. Can you tell me what's different about the doors, or I can go back and check and look myself?
They are indicated in the application. I'm sorry. In the application materials, it's shown with the center mullion.
Oh,
Six
mullion.
lights rather than.
Those in place do not have that.
I'll ask them to change them then.
Are there any other comments from commissioners? The reason we had this item tonight was to express to you the anguish that this commission has felt over this. The damage that has been done by this applicant and this process to the relationship between staff and this commission is really serious. The damage that has been done between this commission and council is really serious. And we've lost a landmark in the process.
I understand.
I do have a card for another comment from the public. I'm going to allow it to come forward even though that period has ended. Carol Smith. The public comment period.
Oh, no, that's number 6.
We, it is.
Neff Lounge?
Yeah.
Go ahead.
There wasn't a public comment. Didn't I put 6 there?
Yeah, I changed it.
Okay, sorry. Good evening, everyone. My name is Carol Smith, 23 Taramina Lane. I have been a member of the council for many years, but I had retired prior to this event. I was very concerned on a number of accounts, as so were Ms. Wald and so were our city attorney. It was a rush job, a tremendous rush job. I don't understand why the inn felt this had to be started the next Monday or whatever. I'm not even sure why they feel they can't be competitive with other five-star resorts without adding cabanas or whatever it is. This isn't Las Vegas. I mean, who are they trying to get? Are they trying to get Jay-Z and Bianca to come here like it's a Las Vegas hotel? I mean, it's just not the inn. I'm sorry. It really irked me. I did watch the television video when some guy with Mr. Crown says, do you know how important this is to him? I mean, he flew all the way from freezing cold Chicago to California to come out here in his private jet. He doesn't exactly have to fly out in cattle class. I mean, I couldn't believe he even said that. I mean, if I had still been on council, I probably would have really had a hard time keeping my mouth closed about how much we should consider that important. The inn has had different owners. The inn will stay the inn. If the Crowns want to sell it, at some point they probably will. We have no control of it. And frankly, I did not get any impression that the Crowns really care what the town says. And I've gotten that impression over a number of years. They did try to work with us on affordable housing when they did their big remodel years ago, but the end result of that didn't add any affordable housing to our stock. So that was a big disappointment, but I didn't have the council on my side on that issue of affordable housing. I'm hoping this new council may think of that more as a priority. Why the council had to 100% give their affirmation to it only takes a matter of 3 of them saying yes. So I was a little disappointed to see that. I think Ms. Clapp she looked at the plans the next morning and she noticed the differences, so she quickly went out to try to correct what she could, which was a lot, apparently, because they were going to do other things. I think what Scott said, our city attorney, is really important about firming up what our ordinance says. And that should be a high priority because the 12 months, all that was so wishy-washy, as he pointed out, that it didn't have any teeth in it. So I think that would be very important for you folks and for the council and for the staff attorneys to definitely get that language real clear what's expected rather than a quote, as you said, 12-month notice. It looks like the grounds that possibly the inn could have sued us if we had prevented them from starting were pretty strong. And of course, they're like Goliath and we're like David. So I think we do have to depend on getting our ordinances really firmed up on this. And then, actually, what Kathleen said to me one day is, this building isn't even landmarked yet. You know, there's a lot of things that we need to do to firm up the ordinance and to actually get things working. And I ran into Jolene Lloyd one day after this, and you know Jolene is really big on history, and she had a great idea which I shared with, which Craig called me on, which is basically, get a group, if we can't call it the Historic Conservancy because it'll sound too much like the Ojai Land Conservancy, but something about having a historic, the historic historic landmarks, something or other, some group of people, maybe 30 or 40 people, who really have an interest in the history of Ojai, because there are a lot more people than are on the commission, and basically get more educated and can serve much more as mentors and as an important group, lobbying group. You see, lobbies count. You know, have a big lobby of people who say, we really need to have this firmed up. We need to have the ordinances. We need to spend the money on A, B, C, and they come to council. It can be very, very effective. So I'm going to work on that, and hopefully Craig's going to work on that, and we'll tell you and anybody else. There's a conflict. Obviously, you're on the commission. You can't necessarily advocate one position or the other, the applicants or the city. So it's a little tricky, but there's many, many people in the city who are not on the commission. I also was concerned that when somebody comes forward for a consideration of historic landmark, or should they apply, there's a $5,000 fee that went from 0 to 5,000. Is that correct, Kathleen? As far as putting out,
You know, the HPC needs to take, the council didn't adopt that fee. It sent it back,
Didn't?
no, it sent it back down to HPC for them to give their input.
Yeah.
And I think it was scheduled, it might have been scheduled for this meeting. I'm not really sure, but we'll take it up soon. But that fee was only presented as a total cost recovery, what it cost in staff time.
well, it may. It also, our staff, Ms. Gould, you're a contract planner, so okay. So contract planners may come and go. So when you have a staff that's not stable that way, their particular love for, interest, and experience with historic landmarks may change, may be different. One idea I thought of would be, perhaps when you're mulling about the fee and all, is it possible that when a applicant comes in who thinks they have a historic landmark, that possibly, let's say Ms. Wald, whoever is our community development person, could say, you know what, I'd like to meet with you. Let's get through preliminaries today. Can you come back? And I'm going to have one of the commissioners come in and listen to our discussion and help you along with this too. If it would be a voluntary basis, of course, but perhaps if we want to make sure that somebody coming in to inquire gets a very encourage and enthusiastic reply from the city, that might be a way to help that happen. That's just the thought I had. And I think this was such a rush job, and it was a rush job because of who the applicant was, the inn. And everybody felt that pressure because they are the inn. And when you rent a room for $500 a night, the TOT is $55. And that goes directly to the city. We don't share it with the state. We don't share it with the county. So it is a huge part of our city income. But everything about it, as you complained about, as Kathleen complained about, it was rushed. The 29th of December, you know, everybody knows that this was a rush job. And what can we do to prevent this again from happening? But I will finish with a nice note. I don't know if Craig looked at it, but there is now a website up called the Taormina Historic District. And you just have to go to taorminahistoricdistrict.org. It's just one word. And one of our residents has put together some of the information that you'll be getting later on. Probably in the spring is when they expect to present the information. But it's terrific. There's also a terrific report that's not around for general consumption yet, but will be available too. And we will be hiring Judy and Mitch, because they're the only game in town as far as I know, which was interesting when you said get a list of 3 together. They would have to come from far and wide. I mean, as far as I know, Judy and Mitch are the only outfit in Ventura doing historic research who are considered professionals. But I think that's a very good idea about getting out of the idea of the applicant has to hire the person. If we did have a pool for various experts to be brought in, I think what Kathleen said is a fantastic idea of having a pool so that they have to put the money in. The applicant puts the money in for the historic record or the engineering report, but they don't pick the person. I think that's a great idea. Anyway, thank you all for all you do, and this was an example that we really need to learn from. So thank you.
Thank you.
Can I just add one more thing onto that? Do you mind?
Go ahead, please.
Okay, so I want to just make this also clear. It's not just about the money being in a pool and you picking in a historic consultant. Sometimes I don't say what I've got in my head. What's really important gets back to what you were talking, Mr. Walker, which is staff then writes the scope of work. And that's what's really important. When the applicant has control, he tells you what you need to do. When I have control, we would write a scope saying, I want this, 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 this. Then that consultant comes back with a price based on this scope of work, all right? And so then that's what makes the fundamental difference between, applicants will say all the time, what does it matter if I pay him directly or you pay him? It's about having control over the scope of the work, and thus the price that you get. So instead of it being, well, what can I get for $5,000? It's, no, I want this. I want you to look at this and this and this and this and this. How much is that going to cost? So there's a little bit more to it than just being the arm's length. I just want to make that clear.
Thank you. Commissioner Hill?
Yes, I just had one comment in regard to your eloquence tonight. As far as establishing a local conservancy, the word Pasadena heritage strikes terror in the hearts of a lot of people that want to tear down everything. And they stopped the 710 freeway and Caltrans from proceeding. And so it's a very, very powerful organization. And I even met some of the people that were involved in it. And so if we need one of their people to come and give a pep talk to a group, if you guys ever get a group together, I'm sure that they would seek us out.
Thank you. I like the sound of that.
Yeah. Oh, yeah, that big group.
Moving on to item number 4, the meeting schedule for 2015 for the Historic Preservation Commission. There has been one suggestion to me that we change our meeting night. I don't know if we want to open that up for discussion now or want to keep it the same on Thursday nights.
Well,
Commissioner Boggs?
my comment was that the city council meets on Tuesday, and when we met on Monday, which we did for many years, then city council got information from us right away. However, we also would miss Monday night football if we changed it.
I thought we just had this discussion in
About
October.
A few months ago.
4 or 5 months ago, we did.
Yeah.
We talked about this, and there were,
But you have a new job now. You can name your own hours.
No. I still work the 12-hour days.
Right.
Well, I work less than you do, probably.
we have two members on our commission now that rely on that day.
Yeah, because I don't work Friday.
Yeah.
So otherwise, I'm in bed pretty soon.
Go ahead.
Mr. Chairman, sorry, not to interrupt, but if you no longer need my services tonight, and in keeping with my cost-conscious nature, I would ask to be excused if that's okay.
Thank you.
Thank you.
Thank you, Mr.
Thank you.
Members of the commission.
Commissioner Roney?
Wednesday or Thursday works, just for my preference. So, but Monday night football's not.
It sounds like we may as well just leave it the way it is unless there are really objections to Thursday.
What was the purpose for changing it once again?
So that the city council on Tuesday night would get our news the next day.
Oh, I see.
So we'll keep our meeting scheduled for Thursdays in the new year, in this year. Unless there is objection. Commissioner Walker?
Are we finished with that question about?
Yes.
I just wanted to point out that Kerry Miller isn't on our agenda, but he came to make a presentation to us, and it might be nice so that he can go home if he could come up and.
Well, then, are we going to, there was also a suggestion prior to the meeting that if it gets too late, that we would shelve the rest of the items for our February meeting. Is that the direction we're heading in here, so we don't get too far into the evening?
Yeah.
Okay, so we'll discuss that. Mr. Miller, would you like to come forward and talk about the theater? Thank you.
Excuse me, just before you start that, what date did you say that meeting was going to be in February?
We're going to stay with Thursdays.
No, I mean for our next meeting. Because you have something here that, item number 7 is a scheduled meeting with the city council and our commission. And you might want to have a meeting before that to discuss that particular item. Would that be helpful?
What is the day of the week of the 10th? I'm sorry. Does anyone know?
It's a Tuesday, right? Tuesday.
So we would be the previous Thursday, would we
We
not?
would be the following Thursday,
we'd be
because
the
we're the
fol-
second Thursday.
Yes, the 10th is a Tuesday.
So are you suggesting we would
Well-
would alter our regular February time so that it would fall prior to the city joint meeting?
Or have the joint meeting scheduled a week later.
You want me to talk to it?
Go ahead.
Okay, I was gonna, those joint meetings are set by the city council, so I can't alter that. That's their prerogative to set those joint meetings, because you're meeting on their terms. You know, they're meeting before their regular scheduled meeting.
And the purpose of the joint meeting is?
They hold them with all the boards and commissions. And my understanding is it's for you to bring up things that you want to make them aware of, that you want either to bring forward to them, for them to direct staff to do. Maybe there's some kind of work program you want staff. Talk about budget, talk about the fees, anything. Talk about the Neff Lounge, whatever you want to talk about.
Okay, thank you. So is there a commissioner who wants to move that we make that our regular meeting immediately prior to the joint meeting? Their meeting starts at 7, am I correct?
No, the joint meeting starts at 6 and their regular meeting starts at 7.
So would it be possible for us to discuss the topics tonight and just put off our questions about our retreat, questions about future items until the next meeting? But
We have,
because otherwise we wouldn't really have time to come up with questions.
yes. Let's do that then, and we'll place that after Mr. Miller's presentation.
That sounds good.
Go ahead. Please reintroduce yourself. Thank you.
Hi, I'm Kerry Miller. I'm the general contractor for the Ojai Playhouse. I've been on board with that since day one, since the Golden State flood. And at this point right now, we're still doing structural analysis. Actually, the analysis was just pretty much completed this last week and presented to the city, to Steve Stewart, for his input and evaluation as well. The plans and intent is not to change the structure at all. From a visual standpoint, at least on the exterior. Interior of it, we haven't even discussed specifics of how that will finish out. But it will look the same. The only thing that has been, there's been a conversation with via the owner, Khaled Alawar, is to change the color and the texture. So the texture that's there, actually there's 3 different textures on the building right now. He would like to change the exterior, and to the same color as the tower of the post office. And a similar texture to either that or to the Oaks. The Oaks is a smooth mission type finish. The tower is a fine sand finish. But they all have that smooth appearance. What's on there right now, on the most of it, is an old 50s or 60s spray texture. Which is, I don't know when that was put on. Looking at some photographs back from the 50s, and it seems to have that texture on it. But it definitely is not the same texture that was there back when it was built in the photographs that I see from 1916 and 1920. Because it has right now, what we pulled off of that east wall was just a standard lath and plaster. Definitely not the original. So don't know what the age of that was. The other thing on that exterior wall, I mean, as far as the paint, I don't know if you recall, but it's the white color that was the whole building right now, but at the bottom there was like a rust color wainscot. And then at the very back of it, which has been removed but will be rebuilt, is the archway going through that back entrance. That had 2 additional colors. And then the rear of the theater is another color. And so the intent was to try to make it all uniform and get rid of the various different colors. Once again, this has to go before the Planning Commission to be all be approved, but that is the intent of the owner right now.
I'm sorry to interrupt you.
Go
Is
ahead.
it the intent to get rid of the sort of maroon base?
Yes,
Good.
exactly. There has been a lot of public outcry about, that has been going around about windows. And somehow here 2 or 3 weeks ago, just prior to the article that came out in the Ojai Valley News where I discussed that there weren't going to be any windows in there, there was stuff going around that, oh, thank God there's going to be windows put back in there. I had heard that, a comment from you that those were never really windows up there, but they were vents. But having windows in a theater just doesn't make sense. So there will not be any windows. But there has been some talk, and I think this is something that the Arts Commission may present to the Planning Commission, the council. This has nothing to do with what we're doing now, and this is down the road of maybe doing some sort of public art on that wall. There's been just some discussion on that. Whether that will ever happen or not is yet to be seen. But that has nothing to do with what we're doing now. So going back to where the work is, we have completed the foundation on the east wall and the reframing of that. It is the areas of plywood that you see missing are there strictly so that we can get some equipment in there to finish doing excavation on the inside, finish doing our foundation work, and they'll allow diesel fumes from the equipment to be able to escape. We'll put fans up there. But once we're done, that will all be sealed up. We still have foundation to work to complete on the south wall and the west wall, west interior wall. And then once that's all done, we will put a slab in there and start restoring the interior. Exactly what's going to happen with the interior, don't know. It will, in general, look the way it was before. Although I have never seen any photographs of the way this theater looked prior I don't know if there are any. I've only seen exterior photographs. But it will go back in general to the way it looked just prior to the flood. New seats, the walls, there'll probably be some additional acoustical tiles or paneling of some sort going on just for make it a better theater. So.
But all of the roof line on the front of the building and the tiles and everything.
Exactly. And all the tiles will go back. The roof line, it will all stay identical. Not planning on doing any changes other than the possibility of changing the texture and the color.
I'm sorry. Go ahead,
The
Commissioner
place where the popcorn is sold and the bathrooms, were they damaged?
No, they were not damaged. At least not externally. It's just the foundation underneath that area. So that will all go back just the way it was.
I have a question. You have a rare opportunity to slope the floor in a way that you can see over people's heads. Will you be thinking about that?
Yes, we're having lots of discussion about that, and what has been definitely determined that we will not go back with the high back seats. Because
Right.
that was a real big problem for short
people.
You know,
Also, I have two historical notes from when I was a child. One is I can remember the theater being filled with cigarette smoke.
Yeah.
And the other is there was a crying room at the very top of the theater, just for historical
I
perspective.
remember hearing that as well.
One more
But there won't be a crying room going back.
One more story is buried alive next to the theater. William Swanson owned the theater from 1935 to 1949. And in the 30s, he did everything he could to get people to come. So one time he decided to bury himself on the side, on Signal, across from the post office. He was on his back, it had a glass cover and a stovepipe so we could talk to him. I was a very young child. And the only thing I remember him saying is, "Boy, it's really hot in here."
When was that?
Back in between 1935 and 1940.
I have one question, and as a user of the post office, when will we get our parking spots back along Signal?
That's a $1 million question. At the present, things are on temporary hold with the project while the two different insurance companies for Golden State, they're in transition of moving from one settling things into the other one while they get their financials figured out as to who's going to pay what and when.
Yeah.
That should be
I'm
easy.
anticipating having some answers on that probably next week, and then we will get moving again. But it may still be a little while. We need to do the foundation work on the inside. We need to keep that rear swath of plywood open so we can get the equipment and dirt and materials in and out. We don't want to go and put in new curb and gutter, which is going to go in, and new sidewalk, and destroy that with the equipment going in and out. And I can't stucco that wall until that's closed up. So once we have that foundation work done, we can close it up, get it stuccoed, and we'll get the sidewalk back. Yeah, we will be able to move the fence up, and I'll leave it up to Greg Grant with Public Works to decide whether those spaces right there can be opened back up temporarily. The sidewalk will not be opened up for a little while, for a few months. So that's the
Thank
best
you.
answer I can give you.
If you could come back to us with the colors and if you could, like the north and east elevations colored.
Okay.
I like the idea of a single color a lot, including, I think on the front it has a contrasting color on the top as well.
No, I think it's all the same color.
Okay,
in the
that's
front.
great.
Except for there is a concrete cap that does have a contrasting color.
At the base.
It's about 8 foot up.
Okay.
off the ground, and it runs across the front and about 8 feet down the east side, and that will be going back up on the east side.
So that would be a continuous color, I'm assuming?
Yeah, that would probably remain the same color that it is now.
Okay.
There really hasn't been discussion about
All right.
changing the color of that, but that will be a contrasting color.
Okay.
Chair, I just want to, it's my apologies, he wasn't agendized, and so, we had asked him to come give a presentation, so we just need to make sure that, because it wasn't agendized, we keep it kind of tight.
Thank you.
One other little tidbit that I'll throw in there, that, as most everybody knows, we ended up drilling caissons along Signal Street. The one that we were drilling at the very front, which is would be the northeast corner, about 7 feet down, which is about 10 feet down from the sidewalk level. They pulled up some dirt, and inside of it was a small jar that has some imprints on it. We did a little research on it, and it looks to be a jar, and it came out intact. The jar was manufactured between 1880 and 1910, and was fully intact 10 feet down in the ground.
Wow.
So all these things have been saved, and we have a variety of things, and I think the intent is to give all that stuff to the museum.
Thank you.
Yes,
Thanks for your
Kerry, I
report.
remember you showing me that jar and telling me the story, and there were some other gems that were
Yeah.
harvested from underground.
Yeah, that's the oldest one. We've got some, we found, I think, 4 or 5 horseshoes of various different vintages and a variety of different glassware, and just found a grease, or like some sort of an oil or grease can, which may have been old popcorn oil, up in the rafters. We just found that a couple weeks ago. It's like that was probably from the 50s. Anyway.
Thank you.
Thank you very much.
All right. One question, and as we get forward with this and get the design element and the colors, do you want me to bring that to you first, or do I schedule to bring it here?
You would schedule that with staff.
Yeah, bring it into us, and we'll schedule to come back before HPC. But you just deal with staff.
Okay.
And then we'll put you on the next available agenda.
Okay, great.
Sounds good.
Thank you very much. Appreciate it.
Thanks a lot.
Thank you.
With that, we will move to item number 7, which is discussion of topics for the joint meeting of the Historic Preservation Commission and the City Council, scheduled for February 10th, 2015, which will fall prior to our next meeting. So if any commissioners have items they'd like to place on that special meeting with the City Council, now is your opportunity to bring it up. Commissioner Walker.
Well, there's a couple of things. I like some of the ideas that you had put down, Kathleen, about the budget for the USC training. So possibly that would be something that we could talk to them about, because it was so valuable to us that went last year. And I contacted Holly Kane, again, who runs the program, and she gave me suggestions for other segments of that program that we could take. So maybe that would be something that we could.
If I may, I just want to point out that this item was written by Diana Gould, and for all you guys, if we didn't introduce, Diana Gould is our new contract planner. She comes to us with a lot of experience, and maybe Diana can explain to you some of the work she's done with historic preservation.
Thank you, Chair, members of the Commission. Diana Gould. I've been in the planning business for about 30 years. I'm very familiar with Pasadena Heritage. I'm a born and raised Pasadena girl, and I've been a member of Pasadena Heritage for many years. I come here from working for a number of other cities, including I was the planning manager for the city of Grover Beach. I've worked for a number of consulting companies. I worked for Southern California Association of Governments, and I have a very strong background in historic preservation. So the buildings here in Ojai and the work that's being done in Ojai is of great interest to me, number one, and also I have a lot of background and knowledge and expertise that I bring as a contract planner here. And the comment made by one of the audience members saying that contract planners come and go, I've been a longtime resident of Ventura County, and my husband has an established business in Moore Park. We live in Moore Park, And I don't intend to come and go from Ojai, so as long as the city would like to have me as a contract planner, I intend to be here and hopefully, serve effectively as the liaison from staff to the Historic Preservation Commission.
Thank you. And
Thank you.
also, I had a couple of others too, if I could. I would like to bring up the topic of the fees, if we could talk to them about the historic preservation fees, and maybe the possibility of our forming a subcommittee. Maybe that doesn't have to do with them, but this commission forming a subcommittee to look at the ordinance and look for places that we can add something on, maybe archaeological resources that we can talk about tightening up that notification and what would go into that to make the city attorney happy, so we feel happy because we have more time to deal with things.
I would just like to interject that I got an email. Did you get one also from our friend at SHPO? I'm sorry, you said his name, Sean.
Oh, Sean, I did talk to him, and he said I think that would be a great idea. He was talking about holding a historic preservation workshop here
Well,
in
he
Ojai that would be
emailed me
open.
today. I guess you didn't get copied on
Oh.
it, did you? Okay, I get a lot of emails, more than I can actually read in a day. But he did say that he has reached out to the LA Conservancy and that they are planning tentatively, and I apologize, I was going to have it for you today on the dais, but I got waylaid by a couple afternoon meetings. Maybe I can print it out before you all leave and give you a copy of it. It's a meeting in April. He wants me to, he's thinking about possibly 50 people because he'd invite other cities to come. And so I need to find some kind of venue where we could have 50 people or more in there. And he's talking about doing training, which would include how to tighten up your, and for all you, SHPO is, the State Office of, okay,
Yeah.
all right. We use acronyms all the time, and I'm sorry, I apologize for that. But, so they were tentatively looking to do in November this year, but in November, I asked them to come sooner rather than later, since this is a very timely topic. Maybe might not have as much momentum in November was my concern. So he talked with his folks, and they're looking at April. So, so you will have that training and those opportunities. So I
Okay,
just want to make sure you understand that is coming. That is coming forth.
that'd be great.
Commissioner Hill?
Yes, I would like to see on that agenda with the city council, a bottom line type of item that would project the topic of ordinances so that we don't get caught into this type of scenario that we have had here in this last month. And also be very specific about timelines in regards to those ordinances, that we don't have a situation where somebody comes in and said, we only have 3 weeks to get this done, and we want to put this on the fast track. No more fast tracks. We would like to see it done for everybody, the small guy, the middle guy, and the corporate guys, all on the same page. So we don't have, because all this did is, as Darwin expressed, all it did was injure the feelings of the people in the community, whether it be our commission, whether it be staff, whether it be the city, the council, whatever, it's damaged that. And I don't want to see that happen. We live in too great of a town for that to happen again. So that would be kind of a bottom line type of item.
Thank you, Commissioner Hill. Any other topics that another commissioner would like to add for the February 10th?
Possibly put on the agenda the issue of potential applications that come in for historical districts within the valley. Just an open discussion about that. I know Commissioner Walker and I spoke about that before, but
Thank you.
maybe opening the dialogue for that.
Thank you.
And
Can I, excuse me, can I also remind you that at one time, different commissioners have expressed to me to bring back up to the council the issue of not only the landmark properties, but those on the historic sites of merit. And putting something in the ordinance that then talks about what you can and cannot do or what's required. For instance, maybe altering the ordinance to require a phase one. I think I spoke to you about this. If you are a building over 50 years, wherever you are in Ojai, you're doing a phase one historic report to do anything. So maybe thinking beyond just the landmark status and what this fiasco is with the landmark status we heard tonight, but also the sites of merits, you know, so that when you have identified things, at least staff is getting a historic report so that we can, you know.
Actually, actually, we did embark on just such an ordinance, a 50-year ordinance, and caused a huge uproar in the community, and it kind of grew out of that, the list of the historic sites of merit. So we're perfectly willing to talk about that again, but
Maybe you'll have better luck.
Maybe you'll have better luck.
Our survey.
I just want to explain to you that,
survey.
you know, staff likes having more information than less. So we would like it if people, we don't know when we get somebody in and it's an older building. I didn't, you know, so we would like it if we were getting a phase one, and maybe there's some parameters, maybe certain minor things could be cut out from that. But when a person's coming in and doing certain renovations, you know, and it's an older building, it would be nice to have that kind of information. And I don't know if 50 years is the threshold that SHPO uses. Talking to Sean, he says most cities use 45, so that they're kind of under the state guidelines. So you might want to consider that.
I think probably, we're not opposed to that. Trust me, we just want to stay out of hot water with the community, but maybe the path of least resistance would be to expand our protections for historic sites of merit and enlarge our list of historic sites of merit, but we can discuss both.
Well, I'm not trying to, you know, be pushy on this subject, but I just want to make sure you know that you have kind of all the facts, you know. And so one of the staff reports that for this next city council meeting on Tuesday, I was asked to write a staff report about director's exemptions and cultural resources as it regards to archaeological resources and zoning clearances. And one of the things I've been asked is the community where I used to work in Morro Bay, anything within 300 feet of a known archaeological site requires a phase one. It's just a threshold. I presented that. You can get it in the packet. If we're doing that with cultural, you know, as he says, prehistoric, it would be a good time for you to suggest, yes, baby steps. What we need to do is, we're not saying you can't do something with something on the sites of merit, but if you're on the sites of merit, guess what? You're doing a phase one, because you're giving at least a historic context to what's coming forward, giving more information for the decision makers. So I think you could kind of tag it in there really quickly, really well, I would think.
I'd like to
Commissioner Boggs?
put on our agenda fences that are built without permits in front of landmarks, homes.
Well, that was one of my points, was the whole enforcement issue, because I think there's been a couple of examples of that, one of which is the house on Foothill. I think we're still up in the air about it, and it's kind of a thing that we'd like to see resolved, is how do we enforce these where people do build walls or do make additions, call it a wall or any addition to their property that is not compatible with the historic. And that compatibility is important, because even if they add a fence, you know, you still have to make it compatible with the historic nature of the property. And if people back in the craftsman days never had fences over 3 feet tall in front of their homes, then that's something that needs to be considered. So even if they talk about building a fence and it fits within the building code to build a 6-foot fence, it may not tie in with the historic nature of the landmark, and so should be brought before us as a work permit. And if they don't do that, then not only have they violated the city law, but they violated the terms of their landmark agreement, which is that they would maintain it as a historic property.
Thank you. Anyone, Commissioner Akins?
Yeah, one other question that's come up and maybe would be a part of the meeting is, when people are coming, you know, when did they go to the HPC and when did they go to the PC? Because I understand that one of our historic sites of merit went to the Planning Commission. the ice house on Fox Street. And I don't know if we know about that, so.
I think that's another, would be something that you'd want to address in the code. You know, you have jurisdiction over the work permit that's issued when it's landmarked. The planning commission has discretion on whether to send it down to you for review and comment to bring back up, because obviously design review permit is their purview. That went last night. This is like my third consecutive night meeting. And I offered that to them, and they chose not to take that option because, you know, for whatever, I mean, I did the best I could to present both sides to it, and I told them, you know, it's a courtesy to send it back down to, or send it over, I shouldn't say down, but over, however you want to say it, to the HPC, you know, and and they were, you know, the applicant obviously had done the work already, which I also expressed in my staff report that the work was all done. I was very clear that there would be no delays in sending it to you for comment because the work's already done. But again, there was this issue, well, if the work's already done, then what does it really matter? And I think we have to get beyond that, because people are doing work in Ojai all the time. And regardless if they do it without a permit, that doesn't, you know, validate their design concept. So, so I think that's another thing that you need to, you know, you don't need to bring up to the city council exactly what you want to do with the ordinance, but you could ask, you know, gee, this is what we'd like to work on during the 2015, and we would like to have the budget, and we'd like to have some carve out of staff's time. Obviously, we're lean on staff, you know, and so, you know, we work a lot of hours, and there's a, and so, you know, getting your niche in there for a certain amount of carve out of staff time, I think is really important. You know, and I think it's really great because, right, you know, as Diana said, we're very fortunate to have someone who has some experience with historic preservation, and I believe you actually sit on a board, don't you?
I do. I'm on the Moore Park Historical Society Board of Directors as well.
Thank you.
So I think that's a good idea.
So I think we have quite a few topics to place on the agenda for that meeting. At this time, do you have, if there are no further comments on item number 7, I'd like to move to item 8 quickly, future agenda items from staff.
Present that?
Yeah.
Can I just ask for a point of clarification? Did you guys move and approve the meeting schedule?
No, they didn't.
I'd like you to just make sure you take action on that.
Okay, and we do need a motion that we keep our meeting schedule the same for second Thursday.
I'll make a motion that we keep our meetings on the second Thursday of the month.
Do we have a second?
I second.
Thank you very much. I'm sorry. Roll call, right? I get to do this
Yes.
again. I'm not used to this. Oh, there he is. I never see your name. Say your name for me. Roney. Well, I just want to think of Mickey Rooney. I have no idea why. Commissioner Boggs. Oh, I'm
Yes.
sorry. Yes, thank you. I'm sorry.
Yes.
Thank you. Commissioner Hill.
Yes.
Vice Chair Walker.
Yes.
Chair McCready.
Yes.
Commissioner Basacha.
Yes.
Commissioner Akins.
Yes.
Thank you. Motion passes. And then are we going to address the issue of chair in that again?
We're going to shelve that to our next meeting. I'd like to shelve it to our next meeting. I've had requests from some of my fellow commissioners that if the hour got late, that we would defer our housekeeping items to our next meeting.
So I have a question regarding the next future agenda meetings. Are you folks going to be up for having 2 meetings in the same week? Or would you like me to check with Sherry and see what calendar is available and what days on a Thursday are also available in February, so you're not doing 2 meetings in the same week?
Are there objections to 2 meetings in the same week?
You're fine?
I think we're good.
All righty then. Okay, that's great.
Strong group, huh?
And so we have, yes. So we have,
Point of clarification.
okay. I mean,
Just a point of clarification then, Chair, if I may. The 2 items
This
that you're
may be my last
proposing to
meeting.
have at the next meeting are the nomination of chair and vice chair, and also the work plan for 2015, is that correct?
That is correct.
Okay, thank you.
So that brings us to item 8.
With the
Director
future
Wald.
agenda, I'm sorry. I must be the third night meeting in a row. We're talking about the future agenda items.
Yes,
Is there
thank
any, and so we have the comprehensive sign program for the Ojai Valley Museum. We do have, just so that you know, we have the DRP going forward for the Twice Sold Tales bookstore to the next Planning Commission meeting, which February the 4th. And then we have the landmark going forward to the city council. So there's all kinds of things going on with this Twice Told bookstore. So with that said, I don't know if there's any other items that you would like me to add on to the agenda, which would be the comprehensive sign program, the two you just deferred. Is there anything else?
Were we going to talk about the enforcement on Foothill property?
I'm sorry, the what?
Foothill property with the wall, were we going to talk about?
Are you, which one exactly are you talking about? You
Gatehouse, the one,
Okay.
Right.
the one where they built the wall without the permit?
Do we know the landmark number?
Yeah, we'll bring that back. But can you give us a prompt of what you want us to do?
Well, they put the wall up without a work permit, so we would just wanted to question. My question would be, first of all, what is the consequence of doing that? Are they required to put it back the way it was? And then the second question is, would we have any interest in looking at their Mills Act status because of the fact that they've acted without cooperating with this commission?
And also, we cannot see the landmark home anymore.
Yeah.
Okay, so what I'm hearing, and I'll reiterate so you can correct me if I'm wrong, what staff will do is we'll put together a package that has their landmark criteria, which should have the resolution, the findings, et cetera, the Mills Act, so you have all that documentation of what was given to the applicant, what they could and could not do, and then do research on whether it required a work permit, whether it required a permit, and if so, if it was done without permit, then what would be the ramifications?
And then also remember, there's this whole compatibility issue. I mean, even though it may not have said you can't put a wall up, well, if they do put a wall up, it has to be compatible. It doesn't even matter the other. You can't just allow a landmark to have any old wall go up. They couldn't build a steel, super modern thing around their house and have that be compatible. So I think that's a whole issue that we have to look at, that just because they're allowed to put a wall up, what is the wall they're planning?
And I think that gets just back to the same thing about tightening up the ordinance so that, you know.
It does, because
Well,
it's the Secretary of the Interior standards that kind of underlie this, and that's why we're here, is to make a judgment as to whether they are following those standards and whether they are maintaining. And if they're not going to, then should they have Mills Act status where they're getting a tax benefit when now the public can't even see the house, and also their wall isn't compatible with it. So, you know, I think. Well,
I just want to, you know, I don't, it's a late hour, I don't want to get into it, but you know, I guess then if that's true, what you're saying, then staff needs to clarify, because, you know, that certainly isn't the way that the information is conveyed to these people that are buying these landmark properties. I'm just saying that's just not the way it comes off to them. You know, they will, I mean, we kind of get in the middle of this, and, you know, like I said, the work permit and the findings that are in that resolution, all those ones that were then enumerated for the Neff Lounge, that's what we have to go by, is if what they're doing affects any of those things. And so, you know, that, I don't know that even staff is telling somebody who's coming in for fencing, if you're a landmark, you're doing a fence, you require a work permit. If you remember, I mean, you know, it's some of these people that come in with landmark status, they challenge staff. I mean, for instance, was when the arch was you know, fell off. I mean, he didn't want to do a work permit, and you know, it was meeting after meeting and attorneys and he never did do one, you know. So I'm just trying to say that, you know, it's difficult sometimes, you know.
I think that the issue there on that one was, was it a repair or was it an addition? And we brought it up here, and we decided that as long as they put it back the way it was, they were repairing it. But then when they
Right.
come and they want to add a 6-foot wall that changes the whole historic look of their property and isn't appropriate, then that's something that it says right in the ordinance, that if they want to put any addition in, it has to come before us
Well,
to
we'll-
make sure it's appropriate, not to say you can't put a wall in, but that it's an appropriate wall for.
We'll bring back whatever, we'll look at the code and we'll bring back what we can. I wasn't here when that wall got up, was put up. I'm not really sure. I mean, it's been an issue again. I know Mr. Shamshiri's been here a number of times, but he didn't build his wall. Fences and walls are, even on non-historic houses, are very hot topics right now in Ojai. We're dealing with one where somebody put in a redwood dog-eared fence in an area which is open and oak-treed, and even on non-landmark, the citizens are very upset. So I understand it's a hot topic. We'll do what we can.
Thank you.
The neighbors were, I was up there, and the neighbors were all just complaining about this wall. They thought it was terrible.
Okay.
The interesting thing about that, when we went to Mr. Shamshiri's house, and he was explaining the wall he wanted to put up, they were at work across the street putting up this wall. And I'm sure that he looked over there, and so this wall going up, and he's gone before the Historic Preservation Commission, invited him up to his house, and he's looking across the street, and those guys didn't get anything. They just put up a wall.
All right, so Diana will take this on, and we'll talk about it together. I know Heather had worked on it before. I never actually worked on it, so my apologies for not knowing more. Maybe I'll just bring it back to you. I think that's fine. Is there anything else with that agenda?
I don't think so.
Then we're great.
Okay.
Thank you.
Thank you. I think we've already had our public comment period, unless there are more comments from the public. I'm open to that. Any commissioner comments that commissioner would like to add at this time?
Oh, go ahead.
We have a new little boutique in town.
Your mic's not on, Commissioner Boggs.
We have a new little boutique in town next to the silver shop towards the drugstore at that end of town. And I went in and met the owner, very nice lady, and she knows all about the sign she has to do, and so she'll be coming. And I was wondering if maybe we could put people that want to get permits for their arcade signs, put them at the beginning of the agenda. I know last time Carolina, who opened the little olive oil shop, she's had to sit there over 2 hours, and then her little sign thing we passed in 5 minutes.
We'll do that.
Thank you.
Thank you. Mr. Lewis, do you have any comments as our museum liaison? Are you invigorated?
Indeed I am, Chairman McCready. The museum just opened our new exhibit, Fine Portraits, Fine People, bringing history alive with striking portraits, paintings mostly of historical and contemporary people, including one David Mason, I'll point out. And there's kind of combines art and biography, and it's a fun exhibit, and people should come check it out.
Oh, I had another comment.
Commissioner Boggs, this is your last, by the way.
Do we no longer have a council liaison for this meeting because of what happened?
I'll get to that after the commissioner comment period. Commissioner Walker, please.
I would just like to take this opportunity to commend Mr. Tony Voog for his work in repairing the arch. I drove by and looked at it and talked with him, and it looks really good. He put, well, I guess his insurance company put $12,000 into repairing it, and they got someone who took a lot of time, and it looks really good. So I think we ought to praise people when they take it upon themselves. It was not only him, but his neighbor who lives in the cook's house
Renee.
across the way, Renee. They collaborated together to make this happen, and it looks really nice.
Why can't we send them a letter?
Well, that
We
would
can.
be nice. We should.
We should do that. I'll put that together. And as there is no council liaison tonight, the record will show that no one from council is here. Not a good move. With that, we adjourn.
Good point.
Good meeting.
Actually, I didn't miss the council person.
Flying sparks.
Actually, I didn't miss the council person.
USC thing again would be great, wouldn't it?
We also recently posted on our website, which I just approved today.
What was it?
Something about Officer Quijada.
Oh, Chamo Quijada, yeah. Nobody knew that, did they?
Every 2 or 3 days, I go back and.
Oh, okay. Yeah, thanks.